progressive, soft-on-crime, anti-victim policies. Felony armed robbery charges get reduced to misdemeanors. He instructed his staff, except for homicides, not to seek prison sentences for individuals. And guess what came next? Rising crime. During that first year, violent crime in Manhattan was at an all-time high. New York City saw a 23% surge in major violent crimes. In fact, we heard from some of these victims of crime at our field hearing up in New York City 13 months ago. A mother whose son's murderers were allowed to walk free because of Alvin Bragg's soft-on-crime prosecutors. A bodega owner who was violently attacked, yet Bragg's office initially charged him. And finally, a father whose son was attacked in Times Square because he was Jewish. And Bragg offered one of his assailants a sweetheart slap-on-the-wrist deal, even though he had previous run-ins with the law, showed no remorse, and was arrested while out on bail. A few weeks after this day one memo, Alvin Bragg told one of his prosecutors, Mark Pomerantz, quote, he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. That's right, after campaigning on going after the former president, Alvin Bragg gets into office and realizes the case against President Trump is ridiculous. And that's why the Southern District of New York didn't bring it. That's why his predecessor, Cy Vance, didn't bring it. Everybody knew Michael Cohen couldn't be trusted. In fact, his former lawyer sat right in this room and told us, you can't believe what this guy says. Michael Cohen's lied to Congress, he's lied to the FBI, and he's lied to court. It's not often you can lie to all three branches of government and yet become the star witness in a prosecution of a former president. Now, what caused Alvin Bragg to do the 180-degree turn? What caused him to change? That special assistant district attorney, Mark Pomerantz. The guy Alvin Bragg had told he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. That guy resigned in protest of Mr. Bragg's decision not to go after President Trump. And his fellow assistant district attorney, Kerry Dunn, resigned as well. And they leaked their resignation letter to the New York Times. And after that, the left begins their pressure campaign on Mr. Bragg, and suddenly the, quote, zombie case is resurrected. And also, never forget, in November of 2022, President Trump announced he was a candidate for president of the United States. And just a few weeks later, Alvin Bragg hires former senior Biden Justice Department official Matthew Colangelo to come up and run the prosecution. Someone who had a history of taking on President Trump and his family's businesses and had also worked for the New York State Attorney General. Alvin Bragg, the partisan DA that campaigned on going after President Trump, whose newly hired lead prosecutor for the case also had a history of taking on President Trump, had their case now in front of a partisan judge. A judge who had donated to President Biden, who imposed a gag order on President Trump, prevented an expert defense witness from testifying, and also told the jury they didn't need to reach a unanimous decision. And there is the fundamental issue. No one knows what the federal crime is. Bragg and Colangelo bootstrap charges federal prosecutors declined to bring into some kind of never-seen felony. Former Attorney General Robert H. Jackson warned us about rogue prosecutors. Former Attorney General said this in a speech 84 years ago. The speech was titled "The Federal Prosecutor." Applies to all prosecutors, though. Attorney General Jackson laid out a vision for how prosecutors should behave in a fair and just society. He stated, quote, "Therein is the most dangerous power of the prosecutor, that he will pick people that he thinks he should get, rather than pick cases that need to be prosecuted. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or in a way of the prosecutor, be in the way of the prosecutor himself." And that is precisely what we have here in this situation. Alvin Bragg's prosecution of President Trump was personal, it was based on politics, and it was wrong. And we're going to hear from some expert witnesses today who will give us details into all that. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, we sit here today for one reason and one reason only. House Republicans are willing to do just about anything to protect Donald Trump from the consequences of his actions. On May 30th, a jury of his peers sitting in a state court in Manhattan convicted Donald Trump of 34 counts of falsifying business records in the first degree, for paying hush money to conceal information that could have been harmful to his 2016 presidential campaign. Let's see how that all unfolded.
An unprecedented moment in American politics. Former President Trump indicted by a Manhattan grand jury.
Breaking news. It appears for the first time in American history, an American president has been indicted on federal charges.
The Justice Department unsealing the 49-page federal indictment against former President Trump for his handling of classified documents after leaving the White House.
A federal grand jury here in Washington has voted to indict the former president for his efforts to overturn the results of the 2020 presidential election.
Former President Trump has been indicted now for a fourth time. The nearly 100-page indictment was unsealed last night in Georgia.
A whopping 91 felony counts in total. 91.
The jury a short time ago alerting the judge it has reached a decision in the Donald Trump hush money trial.
Count 1, guilty. Count 2, guilty. Count 3, guilty.
There's 15 out of 15 so far.
He became very still. He had his arms folded across his chest.
Count 31, guilty. Count 32, guilty.
His face was red. He looked upset. He had a frown on his face. He's scared. And frankly, he should be.
Guilty on all 34 felony counts.
We arrived at this trial and ultimately today at this verdict in the same manner as every other case that comes to the courtroom doors.
Let me be clear. This trial was fair and just, and allegations to the contrary represent a desperate, evidence-free attempt to shield Trump from accountability. Today, you are going to hear a long list of allegations designed to undermine public faith and confidence in the jury's verdict. Do not be deceived. These are baseless allegations, and we can take them down one by one. First, Republicans claim that Judge Merchan was, quote, handpicked to handle the Trump case because he had donated $35 to Democrats in the past. This is false. Judges are assigned at random in the New York court system. With respect to Judge Merchan's $35 donation, the New York Advisory Committee on Judicial Ethics issued an opinion saying that he need not recuse himself from the case, and there is simply no evidence that any of Judge Merchan's rulings were biased in any way. Second, Republicans claim that the jury's verdict convicting Trump was not unanimous. This is absurd. The jury instructions plainly stated that, quote, your verdict on each count you consider, whether guilty or not guilty, must be unanimous. That is, each and every juror must agree to it, close quote. The verdict was unanimous on each of the 34 counts. Third, Republicans claim that all of Judge Merchan's rulings went against Trump. This is false. In fact, Judge Merchan repeatedly ruled for Trump, including a critical ruling that required prosecutors to prove willfulness under a heightened mens rea standard. Fourth, Republicans claim that Judge Merchan prevented Trump's expert witness from testifying. This is false. Trump's attorneys chose not to call that witness because he could not have testified about underlying questions of law, which is a role solely reserved to the judge. Fifth, Republicans claim that Attorney General Garland secretly, quote, dispatched Matthew Colangelo, a former DOJ attorney who served as the lead prosecutor on the Trump case, to the Manhattan DA's office as part of an elaborate ruse to plant DOJ prosecutors and state-level officers to attack Donald Trump. This is false and utterly absurd. Last week, the Attorney General clearly and unequivocally told Republicans that they are wrong. The Department of Justice has no record of any communication to the contrary, and Republicans have not and cannot produce any evidence whatsoever to support this nonsensical claim. And that's the theme for today. Republican attacks, one after another, lack any basis in truth or fact. My colleagues across the aisle know this, and yet they repeat their attacks ad nauseum because that is the only play left in their playbook. They didn't like the fact that Trump lost in 2020. So, lacking facts or evidence to support their claims, they instead attacked our democratic institutions, basically claiming that the election was rigged and corrupt. They didn't like the fact that Trump was indicted for mishandling highly sensitive classified documents, so they claimed that Trump declassified them with his mind. They didn't like the fact that the FBI had to send in agents to execute a search warrant at Mar-a-Lago because of concerns that Trump would destroy documents. So they claimed that the lawful execution of a search warrant constitutes a raid and a witch hunt. And now they don't like the fact that an impartial jury found Trump guilty not once, not twice, but on 34 separate counts. So they are attacking the judicial process, calling it rigged, corrupt, and pre-cooked, without a shred of evidence to back their allegations. And why are they doing this? Why are they sowing doubt in our system? Why are they using rhetoric that is guaranteed to generate death threats against the judges and jurors and prosecutors and police involved in these cases? For one reason only: to protect the felon. A felon who, I remind you, faces an additional 37 felony counts related to his mishandling of classified documents, 4 federal counts for conspiring to launch a riot on January 6th, and 13 counts in Georgia for conspiring to interfere with the administration of the 2020 election. Within the bounds of our system of laws, there is nothing Trump can do to escape a trial in each of those counts, or to escape a sentence if he is found guilty on any of them. Trump and his allies know this, and so they are moving heaven and earth to undermine the system itself. That includes the attempt by our chairman to reach into the New York case while sentencing is still pending and drag the Manhattan District Attorney before this committee. That demand represents a completely unacceptable abuse of the gavel. It is entirely inappropriate for us to interfere with an ongoing state prosecution, no matter how much blind loyalty you feel you owe to the defendant. It is also an effort that smacks of desperation, and it seems, from the standing of MAGA Republicans these days, that the American public has caught on. Donald Trump has faced a jury of his peers. Nothing can change that. We here will face our constituents in November. We should conduct ourselves accordingly. I thank the witnesses for being here today, and I yield back.
The gentleman yields back. We'll now introduce today's witnesses. We have first Mr. Andrew Bailey, the Attorney General of the state of Missouri. Prior to becoming Attorney General, he served as a prosecutor and deputy counsel and then general counsel to the governor of Missouri. Attorney General Bailey has also served our country in the United States Army. The next individual, I would yield to the gentleman from Texas to introduce.
It's my honor to introduce Mr. James Trey Traynor. He's a commissioner on the Federal Election Commission, where he served as chairman of the commission in 2020 prior to his confirmation. He practiced law for 2 decades with a focus on election law, campaign finance law, and ethics. He has also served on the advisory board of the Election Assistance Commission, and he's a constituent of mine and lives about 5 miles down the road around the corner from Salt Lake Barbecue. And like my wife, is a Texas A&M graduate. Great to have you here, Trey.
Good to have the Attorney General and Commissioner. Next, we have Ms. Elizabeth Price Foley. Mrs. Foley is a professor of law at Florida International University College of Law, where she teaches constitutional law, separation of powers, and civil procedure. She is also of counsel at Baker Hostetler, where she practices constitutional and appellate law. Mrs. Foley is the author of 3 books on constitutional law published by the Yale, Harvard, and Oxford University presses. And we have the Honorable Norm Eisen. Mr. Eisen is a senior fellow in governance studies at the Brookings Institute. He previously served as U.S. ambassador to the Czech Republic from 2011 to 2014. And we have had Mr. Eisen in front of the committee numerous times. We welcome our witnesses and thank them for appearing today. We'll begin by swearing you in. Would you all please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses have answered in the affirmative. Thank you, and you may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. We'll be a little liberal with that, but around 5 minutes will be great. And we're going to go right down the line. We'll start with the Attorney General, and then we'll move down the line. Mr. Attorney General, you're recognized for 5 minutes.
I want to thank the chairman and the ranking member and distinguished members of the committee for having us here today. The people of the state of Missouri watched in horror as the left's direct assault on President Trump manifested itself in the form of a corrupt prosecution of the president, which resulted in an errant criminal conviction. We are a nation of laws that are supposed to be equally applied. Instead, the left has prioritized its hatred of President Trump above the rule of law. To put it plainly, the left hates President Trump more than they love this country. The term lawfare, while apt, fails to adequately convey the moral depravity underpinning this strategic attack. The Manhattan District Attorney's Office recent prosecution of President Trump represents one of the most morally abhorrent volleys in the left's ongoing barrage of lawfare. This prosecution was politically motivated and is replete with legal error. First, prosecutors are explicitly forbidden from waging politically motivated prosecutions. To the extent a prosecutor is self-interested in a case, that prosecutor must recuse himself. That did not happen in New York. Mr. Bragg was previously involved in civil litigation against President Trump, campaigned on a promise to prosecute President Trump, and then recruited the third highest ranking official from President Biden's Department of Justice to lead his trial court efforts against President Biden's political opponent. Second, the indictment charges President Trump with 34 counts of falsifying business records for making entries in records with, quote unquote, the intent to commit another crime. The charge's reference to an unidentifiable other crime constitutes a deprivation of due process by denying the president a right to be informed of the crimes for which he is charged. Third, the prosecutor sought an unconstitutional gag order in this case. There's a strong presumption against gag orders as violative of an individual's First Amendment right to free speech. Bear in mind, the right to free speech protects not only the speaker, but Americans' right to hear from a presidential candidate. Fourth, the prosecutor perverted the law to meet the facts rather than objectively apply the facts to the law. The statute at issue prohibits a false entry into a business record. However, the financial entries were authentic in that the entities listed received the funds enumerated in the documents. The prosecutor illegally bent the law to allege that these transactions that were accurately recorded were for some other purpose. Fifth, the prosecutor failed to correct the court's error in instructing the jury that unanimity was not required as to the predicate offense that forms the basis for the fallacious charges. The Sixth Amendment right to trial by jury includes jury unanimity as to each element of the offense for which the defendant is tried. The prosecutor had an affirmative duty to object to this violation of President Trump's constitutional rights. Missouri has a unique history that parallels much of what recently happened in New York, with the exception that systems in Missouri countered a rogue prosecutor who filed politically motivated cases. In fact, I filed the lawsuit that ultimately removed her from office and prevented this kind of lawfare. George Soros has repeatedly funded progressive prosecutors who wreak havoc on the criminal justice system at every level. Not only do they prosecute political opponents, but they refuse to prosecute actual violent crimes happening in our communities. In fact, President Biden's Department of Justice is in lockstep with radicals like George Soros and is actively funding groups like the Vera Institute that are turning our streets into war zones. The Vera Institute, a progressive organization dedicated to undermining criminal prosecution in the United States, receives tens of millions of dollars in federal funds annually. My lawsuit to remove the prosecutor in the city of St. Louis uncovered the disastrous relationship between her office and the Vera Institute that resulted in more than a 90% non-prosecution rate of reported crimes. Meanwhile, the St. Louis prosecutor had to be disqualified from cases in which she was politically motivated. Missouri's systems worked in that the judiciary prevented her political witch hunts, and my lawsuit removed her from office after she neglected to prosecute violent crime. The same systems failed in New York. George Soros has funded Alvin Bragg's candidacy, and under his watch, the Manhattan District Attorney's Office has partnered with the Vera Institute. And in this case, the judiciary in New York failed to disqualify Alvin Bragg from his case against President Trump. These facts, coupled with the federal and state prosecutions that have yet to play out, display a level of collusion never seen before between a corrupt Department of Justice and illicitly motivated state prosecutors. I believe the investigations and subsequent prosecutions of President Trump have been illegally conducted in coordination with the Department of Justice. That is why my office demanded communications between the DOJ, Alvin Bragg, Letitia James, Jack Smith, or Fani Willis related to the investigation or prosecution of former President Donald Trump. In order to protect the rights of all Missourians who plan to participate in the 2024 presidential election, the state of Missouri has the right to know what extent the prosecutions of prominent presidential candidates are being coordinated by the federal government, which is currently run by President Trump's primary political opponent. The credibility of our criminal justice system has been undermined and hangs in the balance. If we are to protect the rule of law, we must end the lawfare against President Trump. As a nation, we must affirmatively reject Soros-backed prosecutors who refuse to enforce the law and instead weaponize the criminal justice system to achieve political ends. As a nation, we must eliminate the Vera Institute's influence over the DOJ and our local prosecutors' offices. I want to thank the chairman and ranking member and distinguished members of the committee.
Thank you, Mr. Attorney General. Commissioner, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Jordan, Ranking Member Nadler, and distinguished members of the committee, it's an honor to appear before you today to discuss the critical issue of jurisdictional overreach in the prosecution of federal campaign finance law, specifically regarding the actions of Alvin Bragg, the District Attorney for Manhattan, in his prosecution of former President Donald Trump. No less critical, I want to highlight the inaction by the Department of Justice to defend federal jurisdiction in this case. The Federal Election Campaign Act serves as the bedrock for regulating money in our elections. It delineates the authorities responsible for enforcing these rules, vesting exclusive jurisdiction in the Federal Election Commission and the Department of Justice. This statutory framework is designed to ensure a uniform application of campaign finance laws nationwide, preventing the creation of fragmented enforcement landscape and leveraging the expertise and resources of federal agencies. District Attorney Alvin Bragg's decision to pursue charges against former President Trump for alleged violations of federal campaign finance laws marks a significant deviation from this established legal framework. By doing so, Bragg has effectively usurped the jurisdiction that this Congress has explicitly reserved for federal authorities. This overreach sets a troubling precedent for the politicization of legal proceedings at the state level. The danger here lies in the disparate enforcement standards that torture well-established federal law processes. As an example, the state judge in New York misinterpreted federal criminal mental intent standards and gave the jury an instruction which read, willfully contributing campaign contributions, but the statutory mental intent found in the Federal Election Campaign Act is knowing and willful. Now, imagine 50 states enacting the crime of campaigning by unlawful means, and 1,000 different state and local prosecutors prosecuting presidents, former presidents, presidential candidates, and any number of House and Senate candidates under varying interpretations of FECA by bootstrapping those laws through their state's unlawful means criminal code. It is also disturbing in this case what hasn't happened over at the Department of Justice. Given the clear precedent established by the U.S. Supreme Court regarding the prohibition of state officers prosecuting federal crimes, it is perplexing that Attorney General Merrick Garland and the Department of Justice did not intervene in the prosecution of Donald Trump. The DOJ's election year sensitivity policy is designed to protect the public from being influenced by legal proceedings during an election year. Had the DOJ zealously represented the United States by intervening to protect its own jurisdiction and that of the FEC, this issue might not be the predominant one of the 2024 presidential cycle. A disclosure on May 31st in unredacted FEC documents reveals that the Department of Justice conducted a year-long investigation and found no criminal acts committed by former President Trump. This revelation underscores the problematic nature of Bragg's prosecution and his intrusion upon federal jurisdiction. Again, the implications for allowing local district attorneys to prosecute based on their interpretations of federal campaign finance law are profound. Such actions risk eroding the uniformity and predictability that FECA aims to provide. For me, a larger First Amendment concern is at play here. That is the deterrent that this encroachment on federal jurisdiction will have on well-qualified candidates from seeking public office. Fearing disparate legal standards based upon their locality, preserving the centralized enforcement mechanism envisioned in FECA is essential to a fair and impartial oversight of campaign finance regulations and of our elections. Alvin Bragg's misguided prosecution of former President Donald Trump represents a clear usurpation of federal jurisdiction. Coupled with the DOJ's inaction, it's compounded the issue. The dangerous precedent of local prosecutorial overreach in matters of federal concern must be addressed to maintain the integrity of our electoral system. We must reaffirm the exclusive authority of the FEC and the Department of Justice to enforce federal campaign finance laws, ensuring consistent and impartial application across the United States. Thank you, Mr. Chairman, for the opportunity, and I look forward to your questions.
Thank you, Commissioner. Counselor, Ms. Foley, you're recognized.
Chairman Jordan, Ranking Member Nadler, members of the committee, thank you so much for the opportunity to testify today. I'm going to focus my remarks on due process as a constitutional lawyer and someone who practices in the field. Most of you went to law school, so you remember that due process is part of the Constitution that ensures that the processes employed to deprive someone of life, liberty, or property are fundamentally fair. And of course, we all learned that there are twin pillars of due process. One is notice, and in the criminal context, that means notice of the specific charge that you face, as well as the issues that are raised therein, in other words, the elements of that crime. And number two, a meaningful opportunity to be heard on those charges. And unfortunately, Mr. Trump's New York trial violated both of these twin pillars of due process. And to explain why, first of all, I've attached a flow chart to my written statement that might be helpful as I go along through my oral testimony. But I thought I'd also bring another visual of the Russian nesting dolls to give you some sense of the complexity of the theory of criminality with which Mr. Trump was faced in New York. This first doll represents the actual charges in the indictment against Mr. Trump. There were 34 charges of felony falsification of business records under New York law. And to make it a felony falsification, you have to meet all of the elements of misdemeanor falsification, which means you have to have a falsified business record with an intent to defraud. And then to make it a felony, you have an additional element that must be proven. That additional element is the intent to commit another crime. All right, so the next nesting doll is, what is that other crime that Mr. Trump intended to commit? Well, Mr. Trump wasn't sure, and neither were his attorneys, so he asked the New York prosecutor for what's called a bill of particulars, saying, hey, please tell me what that other crime you think it was that I intended to commit. The prosecutor interestingly responded and said, hey, you don't have a right to know. We don't have to tell you what that specific crime was. And oh, by the way, without limiting the people's theory at trial, that's a direct quote. In other words, without limiting our ability to change our minds during the trial, the other crimes that Mr. Trump may have intended to commit may include one of four things. First, New York election law. Second, New York tax law. Third, falsification of other business records, presumably other than the 34 with which he was actually charged. And finally, the Federal Election Campaign Act, FECA, right? Now, if you hear me list those four possibilities of the other crimes Mr. Trump intended to commit, you see that they're very different crimes, right? They range from state crimes to federal crimes, from misdemeanors to felonies. And within each of those crimes, there are different, or statutes, there's different sort of ways to commit a crime. So for example, under New York tax law, tax fraud was one of the statutes cited by the New York prosecutor in his response to the bill of particulars request. That tax fraud can be committed in multiple different ways under that statute. There's different kinds of ways to engage in tax fraud. FECA, as you probably know, it's the Federal Election Campaign Act, is a federal law that's over 100 pages long. And if you read it, you see that there's lots of different crimes embedded in that one mega statute. So Mr. Trump didn't know for sure what was that other crime that the prosecutor thought he intended to commit. And in fact, the first time he learned what it was during the jury instructions, when Judge Juan Merchan told the jury that that other crime was New York election law. Okay? That's far too late for due process purposes, for purposes of notice, right? That's after all of the evidence has closed. All right, so then he picked out, of those four that were mentioned by the prosecutor, New York election law. And when you look at New York election law, you see even further that embedded in it, there's another predicate. In order to violate New York election law, you have to basically interfere with an election by quote-unquote unlawful means. You say, well, what does unlawful means? Unlawful means that the way that you committed the violation of the New York election law was itself unlawful in some way. So there's a second predicate crime buried in there, right? And then you say, well, how do I know what those unlawful means are? And Mr. Trump had no notice of what those unlawful means were because unlawful means was embedded in the New York election law, which he didn't even know was the first predicate for the basis of the felony falsification charge. And the first time Mr. Trump realized what the unlawful means could be for the basis of the New York election law was, again, during the jury instructions by Judge Merchan. And at that point, Judge Merchan instructed the jury, and I wish I had 3 of these, but I only have 1. I got these in Russia, actually. And the 3 means that Judge Merchan pulled out of the sky, right, were number 1, FECA, again, the federal election law. Number 2, falsification of other business records, although he didn't specify which ones. And number 3, and this is kind of fascinating, quote-unquote tax laws, which Judge Merchan's instructions said could include not only state law, but federal tax law and local tax law as well. Now, to make matters worse.
You can finish up real quick. I apologize. We got just
Hold up.
yeah. If you can finish up real quick.
Sorry. To make matters worse, Judge Merchan instructed the jury that they need not be unanimous in picking out which one of these 3 means by which they could convict Trump. This is a travesty of justice. It's clearly a violation of due process. And if anyone would like to ask me about the Supreme Court's decision in Shad on unanimity of means,
Point of order,
I'd be
Mr.
glad
Chairman.
to give further detail. Thank you.
Gentlelady yields back. The gentleman, the ambassador is recognized for 5 minutes.
Thank you, Chairman Jordan, Ranking Member Nadler, and distinguished members of the committee. I appreciate you inviting me back today for this hearing. You may notice that I'm not turning my microphone on and off. Today is the Jewish holiday of Shavuot, and we do not operate electronics on our holidays. I didn't think I would be able to come at all, but my rabbi gave me permission when I explained the significance of today's hearing. I was in court throughout the 6-week plus Manhattan criminal trial of former President Donald Trump for interfering in the 2016 election and covering it up. I want to make 3 points today. First, a jury of Mr. Trump's peers in the city where he lived and worked most of his life found him guilty. I spent most of the trial watching them, and unlike some in court who dozed, they paid extremely close attention throughout. The jurors got it right. Witness after witness, formerly inside Mr. Trump's orbit, supported both parts of the jury's conclusion. First, that Mr. Trump intended to influence the 2016 election by unlawful means, including in the form of a $130,000 payment to Stormy Daniels to benefit his campaign, over $127,000 in excess of the legal limits. Second, that Mr. Trump covered it up through 34 false business records that disguised that repayment of that excessive contribution as a legal expense. The jury were not the only ones who got it right. So did the judge. I know this may astonish some who were fed a steady diet of disinformation about him, but Justice Juan Merchan bent over backwards to be fair to the defendant. Why should Mr. Trump have been allowed, for example, to act in contempt of court by violating the gag order no less than 10 times before he was warned that the 11th violation would lead to more serious consequences? Justice Merchan was judicious on that and many other occasions, as I believe the appellate review will demonstrate. Second, the jury found Mr. Trump lied to voters and covered it up with phony documents. Does that sound familiar? It should, because we saw this pattern repeat in 2020 with the big lie that Mr. Trump won the election. The false documents in 2020 were fake electoral certificates that were part of a scheme to overturn the legitimate outcome of the election in this body, with tragic results on January 6, 2021. And Mr. Trump is limbering up to try the big lie again. He will not commit to accepting the 2024 election results unless he wins. That brings me to my third and final point, where the real threat of the politicization of the justice system and the weaponization of government lies. The attacks on the trial and verdict by the former president and others are politicizing a crime, falsification of business records, that has been prosecuted about 10,000 times in New York since 2015. Mr. Trump should not be treated any differently, no better, no worse, than those other defendants who falsified documents. His politicization of the case has led to a staggering amount of confusion. such as that there was no underlying crime specified that made his document falsification a felony. Not so. I brought an exhibit also, the May 12th, 2023 Bill of Particulars. That's their response to the Bill of Particulars that did specify the crime. And I have a pile of other documents here showing that that happened over and over again. As bad as all that is, the worst politicization is the call by Mr. Trump and others to baselessly prosecute his adversaries in retaliation for the verdict. Just last week, Mr. Trump pointed to his own prosecution and then said, it's very possible it's going to have to happen to them, to his political opponents. Those words are all the more chilling because they are not isolated to the issue of this trial. We should take them as a warning of what is to come should he return to office, starting with his promise to be a dictator on day one. That would be the real weaponization of government, not Mr. Trump's being held accountable by 12 of his fellow citizens. Thank you.
Gentleman yields back. The gentleman from Florida is recognized for 5 minutes.
We are here at the hearing on the Manhattan District Attorney's Office, and the essential ingredient we seem to be missing is the Manhattan District Attorney, which I guess, Mr. Roy, would be a lot like going to the Salt Lick Barbecue and not getting the moist brisket. Now, to Mr. Jordan's credit, great credit, he sent a letter to Mr. Bragg on May 31st inviting him to come participate, and we got sort of a nasty gram back from Mr. Bragg on June 7th. Mr. Chairman, I seek unanimous consent to enter into the record the June 7th response from AG Bragg.
Objection.
And, I'm sorry, DA Bragg. And in this letter, I'm going to quote from it, Ms. Foley. Bragg says, this office is committed to voluntary cooperation. Do you believe that?
No.
The letter continues, that cooperation includes making the district attorney available to provide testimony on behalf of the office at an agreed upon date. Do you believe that?
I'll believe it when I see it.
It goes on to say that they're evaluating the propriety of allowing an assistant district attorney to testify publicly about the matter. Now, that assistant district attorney is the one who downstreamed from DOJ, right? So you think they're going to provide Mr. Colangelo here to answer our questions?
I would not expect Mr. Colangelo to show up.
And do you base that opinion on the lawsuit that Alvin Bragg filed against Jim Jordan in his official capacity in the Committee on the Judiciary?
I saw some of that, yeah. I mean, look, you have a legitimate legislative purpose to be inquiring as to what you're doing, so they have no leg to stand on.
But they're not going to come because we ask. And they're not going to come because they say so. And we learned that by observing our dear friends at the Oversight Committee. Because this will surprise a lot of Americans. After hearing the enthusiasm around oversight of the Biden crime family, we never sent a subpoena to Hunter Biden to give live testimony before Congress. Let that sink in. The Republican House majority has never subpoenaed Hunter Biden for live testimony in public. We've never done it. And I worry that, we're going about the same kind of process here, and we may end up there in July, right after sentencing, with an empty Alvin Bragg nameplate and an empty Matthew Colangelo nameplate. And then we'll start the process again on letters and subpoenas and accommodation, and I've just grown tired of it. And I think you're right, Ms. Foley, that this is all professional wrestling. There's no real effort to bring these people to bear. So,
will the gentleman yield for a
no,
question?
one second, I got a motion. Mr. Chairman, I move under Committee Rule 4 and Clause 2M of House Rule 11 to require the attendance and testimony of Alvin Bragg and Matthew Colangelo on July 12th to discuss their involvement in the Trump prosecution, including their office's coordination with the Department of Justice.
Mr. Chairman. Mr. Chairman.
Gentleman, ranking members recognized.
It's a little absurd because Mr. Bragg and Mr. Colangelo have already agreed to appear before the committee on July 12th. We have a letter to that effect, so there's no point requiring them to do what they've already said they're going to do. The committee asked them to appear. They asked them to appear today, they made the point that they did, or Mr. Bragg, I should say, made the point that he didn't think he should appear before the sentencing on July 11th, but he'd be available thereafter, and he's agreed to come on July 12th.
Mr. Chairman, this debate's out of order.
You made a motion. It's not out of order.
No, you have to seek recognition pursuant to
recognize
debate
you.
on the motion. You can't
recognize
just
you.
inject.
I recognize you.
I'm still on my time. I'm still controlling 2 additional minutes of time.
You'll get your time, man.
I have a letter here. No, my point is simple. The committee requested them to appear, Mr. Bragg and Mr. Colangelo. They've agreed to appear. They plan to appear on July 12th. I don't know what this debate is about. I yield back. Oh, and I'd like unanimous consent, Mr. Chairman. Yes, unanimous consent to introduce into the record a report from Fox News headlined.
Without objection.
I object pending consideration of my motion.
Hang on, I want to deal with. I want to deal with Mr. Gates' motion. Then we'll take your unanimous consent. Mr. Bragg and Mr. Colangelo have agreed to come on the 12th. If they don't show up on the 12th, they will be subpoenaed. So I would ask the gentleman if he could withdraw the motion. They're coming. We worked hard over the weekend to make sure they're coming. And if they change their mind, they will get a subpoena from the committee requiring them, compelling them to be here. And then if they choose to go to court on that, I think we'll beat them in court like we did the first time when we got Mr. Pomerantz to come testify in front of the, come be deposed in front of the committee.
Time then becomes determinative. The problem is, if we're going to bring these people in, let's go. I've made a motion to subpoena these people now, pursuant to the rules, and I want to vote on my motion, or I want someone to move to table it.
You made the motion to subpoena them for the 12th?
I moved under Committee Rule 4, Clause 2M of House Rule 11, to require the attendance.
I move to table the.
That's fine.
I
Let's take a
second
vote.
that.
It's not debatable.
Gentleman's made a motion. The motion to table is not debatable. Those in favor of committee will stand in recess. he's got 2 minutes. Committee will come to order. The gentleman from Florida has 2 minutes remaining on his 5 minutes of questions.
Mr. Chairman, I will withdraw my motion based on the representations not only that you've made, but that the ranking member has made in our colloquy previously that Mr. Bragg and Mr. Colangelo will be here and willing to answer our questions. Ms. Foley, I wanted to come back to you. You'd made mention of this theory of unanimity, and I wanted to give you a chance to talk about that case law a little bit that you were referencing.
Oh, yeah, thanks. In fact, Professor Eisen and I were just sort of debating that case, Shad, from 1991. So Shad is a case where Arizona had this first-degree murder statute. And in order to commit first-degree murder under that statute, you could either have premeditated murder or you could have felony murder. And the question was whether or not that the jury had to be unanimous in its conviction under first-degree murder, whether they had to make a specific finding that it was premeditated or they had to make a specific finding that it was felony murder. And that case is very split. There's like a 4-1-4 split amongst the 9 justices in Shad. The main plurality written by Justice Souter says, well, in a case like that, that statute, the Arizona legislature looked at the crime as first-degree murder and said that if you committed either by premeditation or by the commission of, during the commission of a felony, you sort of have equal sort of moral culpability to warrant the first-degree thing. And so the jury doesn't have to be unanimous as to whether it's one or the other, all right? But along the way, at the end of that, they said, oh, a point of caution, that if the means by which a crime could be committed are sort of too capacious, there might be due process problems. And then you have a Scalia concurrence that reiterates that concern and says if you have sort of an umbrella crime, it would violate due process. And then you get 4 other justices in dissent who are even taking a tighter position, saying if it's an element of the crime, it must be unanimous.
It almost seems like I get the Russian nesting dolls, but it's almost like a Mr. Potato Head doll, where you're sticking the wrong parts on and ending up with quite an odd-looking legal feature.
Well, yeah, and the thing about New York's election law is it can be violated by any unlawful means, quote unquote. That's the language of the statute. Now, any unlawful means any unlawful means. It can mean a local crime, it could be a state crime, it could be a federal crime, as opposed to the Arizona statute, which is what was upheld, only gave you 2 choices. It was either premeditated murder or it was murder in the commission of a felony. That's much tighter.
Yeah. I see our time has expired, but it sounds like a real constitutional due process issue as applied in this prosecution. I yield back.
Correct.
Gentleman yields back. Gentleman from New York is recognized for 5 minutes.
Thank you, Mr. Speaker, Mr. Chairman. Ambassador Eisen, I want to talk about some of the disinformation that's been spread about the trial in New York. Republicans have attacked Judge Merchan as biased and have suggested that he continually ruled against Trump. What is your response to that allegation?
Mr. Chairman, I was present throughout the trial, and I thought that the conduct of the judge was the exact opposite of bias. He was scrupulously fair. He upheld dozens and dozens of the objections that were articulated by the defense. At times, for example, during the testimony of Stormy Daniels, when the defense did not object, he objected for them, sua sponte, to limit the testimony. I would not have allowed Donald Trump to violate the gag order 10 times, as you heard in my opening testimony, before threatening him that the 11th would require more dire consequences. One of the biggest fights, Commissioner Traynor referenced this, was over willfulness. The judge actually adopted the instruction that was proposed by the defendant and his counsel. I could give you many, many other examples. I thought it was one of the outstanding jobs of judging that I have seen in my over 3 decades in court.
Now, Ambassador, Republicans have alleged that it would be impossible for Donald Trump to get a fair trial in New York City. Is there any shred of validity to this?
I watched that jury, Mr. Nadler. And they paid close attention. Many of them took notes throughout. They included those who said they followed Mr. Trump's statements on Truth Social. The notion that a jury of Manhattanites, where Mr. Trump chose to live and work, where the offenses were committed, cannot sit is really wrong, and I think it's not fair to these 12 ordinary Americans who performed their duty in our rule of law system.
And Republicans have also alleged that Donald Trump would never have been charged with felony falsification of records if his name were anything other than Trump. In fact, this is a common charge in New York. The Manhattan DA's office has pursued these cases 120 times since Bragg took office. Isn't that correct?
That's right, Mr. Bragg has.
Is there any evidence at all that Donald Trump is being politically and unfairly targeted?
Since we're doing exhibits, I thank Professor Foley, a trial lawyer. I love exhibits. For my book, I may even borrow her nesting dolls at some point if the chairman will permit. For my book, Trying Trump, I surveyed almost 10,000 New York falsification of business records cases. This is a crime that is regularly charged. If you do the FBR in New York, you do the time. So there's nothing unusual here about charging false documents.
Thank you. MAGA Republicans' attacks on Alvin Bragg should not come as a surprise. It's a clear pattern. Just look at how Republicans have viciously and baselessly attacked Special Counsel Jack Smith, who was overseeing the 2 federal prosecutions against Trump and conducted the investigations into Trump's criminal behavior. They have desperately tried to discredit Smith to lessen the effects that the indictments have had on his reelection bid, despite the mounds of evidence against him. The former president has called Smith a lowlife who is nasty, rude, and condescending, a Trump-hating prosecutor, a disgrace to America, and a very vulgar profanity that I won't repeat here. He even brought Mrs. Smith's family into the attacks, saying, quote, Smith's wife and family despise me much more than he does, and called Mrs. Smith's team thug prosecutors. These attacks on Smith clearly mirror the attack on Bragg. Why are Republicans going to such lengths to attack these prosecutors? And what are the benefits of delegitimizing them?
Because Mr. Trump is guilty of interfering in the 2016 election and covering it up with 34 false documents. And because the American people understand that that is a disqualification for a public figure in our country, and because that pattern was exemplified again in 2020, is a threat for 2024, and these attacks on prosecutors, juries, judges are of a piece with Donald Trump's promise to be a dictator on day one. That is why they are pushing back.
Thank you. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. So I'll ask you, Mr. Bailey, do you know why Alvin Bragg originally declined to move forward with the prosecution of Donald Trump?
I believe the reasonable inference to draw is that the charges aren't supported by the laws or the facts.
So let's talk about a guy named Mark Pomerantz. So Mark Pomerantz and his colleague, Mr. Dunn, resigned from the office because they felt that Mr. Bragg was not going to go forward with the case. And so he issued a statement. But in analysis, if you start looking at what Mr. Pomerantz said, he said, many members of the team did not think that they could prove Trump committed crimes. Many did not think the New York State criminal charges advanced by Pomerantz applied to Trump's conduct. In his book, he writes, many of the lawyers were relentlessly negative. There were references to our case as weak. One lawyer opined that it had many fatal flaws. Another expressed a view that the case may be way out there. It's not the strongest case in the world. If you go on, there were defectors from the Trump investigation. All of this is taking place from December of 2021 all the way through February of 2022. Now, why is that important? Because I want to get to this, Professor Foley, because there's a timeline issue, and you're talking about due process. And so due process is you've mentioned two pillars, but I'm going to suggest that if you have an infirm prosecution and they're looking to find a way to prosecute because it's a person as opposed to the case. So here's the timeline, which may seem coincidental, but this is exactly what happened. November 7th, 2022, Trump teases. He says, I have a big announcement coming up. September 9th, 2022, at a press conference, Joe Biden says, we just have to demonstrate that he will not take power if he does run, making sure he, under legitimate efforts of our Constitution, does not become the next president. On November 15th, Trump announces his run. Now, here's where it gets interesting. On November 18th, Matthew Colangelo, number 3 in the DOJ, resigns. He gives a 2-week notice in a letter, and he's going to end up quitting his job at DOJ on December 2nd. He's going to work for Manhattan DA Alvin Bragg's office beginning December 5th. And nobody can tell us from DOJ or Alvin Bragg how they even, nobody seems to know. He just apparently, Colangelo just shows up in the office one day. Point 2 on that same date, November 18th, Merrick Garland appoints Jack Smith on 2 cases against Trump, one in Florida and one in Washington, D.C. Number 3, same day, November 18th, Fannie Willis's paramour, Nathan Wade, spends 8 hours in meetings with White House lawyers. And it wasn't too long after that that indictments start falling into place. And we could go through those. I wanted to ask you, Ms. Foley, if a prosecutorial agency is actually searching for crimes because of an individual, and they've stated it. Don't forget Mr. Bragg, and I'm leaving out all of his campaign promises to get Trump. Couldn't name any kind of thing that he had done wrong, but he's going to get Trump. Is that antithetical to the very notion of due process in and of itself?
Yeah, you ask a really interesting question. Yes, the short answer is yes. There is a line of Supreme Court jurisprudence beginning with a case called Rochin versus California in the 1960s, which establishes what's called the shocks the conscience test for violation of due process. You may remember that from law school. It's where your stomach got pumped forcibly against his will. Yeah. But since Rochin was decided, there have been other Supreme Court cases. There's one called Xrel Vuitton. There's one called Caperton involving judges. And this line of jurisprudence under due process says that if you can establish that there was bias by a prosecutor, an investigator, or a judge that shocks the conscience, it's a due process violation as well.
Right, so when we start looking at this, and you realize that there was no theory of the case that seemed to work. I mean, that's from Mr. Pomerantz's testimony. They couldn't come up with a case. You have prosecutors saying, we can't find anything here. And then all of a sudden you get jury instructions like you have here. How antithetical to that is to due process?
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias. And, whether or not it would shock, the left side of the aisle's conscience, I don't know, but it certainly would shock mine. I'm trying to be pretty objective about this. It's a high bar to shock someone's conscience, but, basically the idea is, if you're doing the Attorney General Justice Jackson maneuver of picking the man and pinning some crime on him, then yes, I would hope that would shock your conscience.
Thank you. Yield back.
Gentleman yields back. Gentleman from Tennessee is recognized.
Thank you, Mr. Chair. This committee has engaged in many off-the-wall, pointless, politically driven hearings this Congress. Seems to be the mode. We are in the basic format of trying to do everything we can to defend one of the most lawless people in this nation's history, Donald Trump, who has been found civilly liable numerous times in New York for tax fraud, for rape, for defamation, and for violating the New York State tax laws. And now, 34 times for a felony and a criminal action for interfering in business records and interfering in the election of 2016. Now, of course, he's got other federal cases coming in Florida, where he has his friend, Judge Eileen Connor, Cooper, whatever her name is.
Cannon.
Cannon, and he's got Georgia, and he's got Jack Smith on overthrowing the government and January 6th. But this committee concentrates on defending him and bringing up his case. We've got crime going on in the country. We've got immigration problems in the country, problems at the border, but nothing's more important than defending the number one person criminal, civil defendant and criminal defendant in this country in the history that I can remember over the years. Nobody has been in court so many times and had so many losses. Yet we defend him here. This is an attack on the rule of law and on democracy, and it's a very, very unfortunate. These are political purposes that this committee has publicly, aggressively, and despicably tried to intervene in a criminal proceeding. We are a nation of laws, and those laws are enforced through the judicial system. The federal government has specific duties, and state governments have specific duties. Both are equally bound to satisfy the principles of due process and equal justice under the law. But this isn't what we're looking at here. We're looking at what the GOP has done to try to run this committee as a Trump legal defense team. I mean, they've just met with Mr. Trump over in the Capitol Hill Club, and I'm sure he did a Harvey Korman impression of, you go do that voodoo that you do so well, when he sent the Klansmen and the Hells Angels and all the other despicable characters round up together to go into Rockbridge. They're here doing that voodoo that they do so well. And they're losing, as Trump and his lawyers lost in Manhattan. 34 times a felon. And they tried to say, this is about you, not about Trump. Well, it's malarkey. Ambassador Eisen, as a general rule, judges interpret the law and juries are finders of fact. Can you please tell us what that means and explain it to the people here who might not have an understanding of that theories, and what happened in New York?
The principle that judges interpret the law and juries find the facts is a foundational one in our American rule of law, Anglo-American rule of law system. The reason we ask judges to interpret the law is because they have the expertise in what the law means. The reason we ask juries to determine the facts is because in the American justice system and in its role as a foundation of our democracy, we trust the fate of a criminal defendant ultimately to their fellow Americans. That is exactly what happened here. One of the many canards that we've heard, Mr. Cohen, is that one of Trump's witnesses, former FEC Commissioner Brad Smith, who I've known since we were in law school together, I edited his note, was prevented from testifying. No, he was welcome to testify. He was free to testify. The only limitation was he was not allowed to instruct the jury on the law, because that is the job of the judge.
And you saw Judge Mercan preside over this case.
Every day.
What kind of job did he, what you saw and what you have heard from others, did he perform?
I thought that everyone in the case, including Donald Trump's own defense lawyers, who I praised, I wrote a daily trial diary published, and I dedicated one to singing their praises myself as a...
So Mercan was highly rated.
Mercan was one of the great judges that I've seen.
Thank you. I've got it. Ms. Foley, one question. Is Trump in one of those nesting dolls underneath Putin?
Where? What? Which?
That's the ones I've seen. I yield back the balance of my time.
Gentleman yields back.
Mr. Chairman, I have some UC.
Gentleman has a unanimous consent request.
Thank you. Article from CNN, former President Donald Trump announces White House bid for 2024. Article from The Hill, Biden suggests Trump will not take power again if he runs in 2024. New York Times article from December 5th, 2022, Manhattan DA hires ex-justice official to help lead Trump inquiry. February 7th, 2023, Pomerantz versus Pomerantz, an annotation of his leaked resignation letter in Manhattan DA Trump investigation. These from Business Insider, Donald Trump again teases 2024 presidential bid, saying he'll make a big announcement on November 15th, same day Mike Pence's memoir is scheduled to be published. February 23rd from the New York Times, 2 prosecutors leading New York Trump inquiry resign, clouding case's future. May 6, 2021, FEC drops case reviewing Trump hush money. From Washington Examiner, for Prosecutor Bragg, Trump indictment is campaign promise kept. And Biden's number 3 man at DOJ resigned to join Alvin Bragg's Get Trump team on November 18th, 2022.
Without objection.
Thank you.
Gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. Of course, the leftist lawfare didn't start here. I think it started when the Democrats used the IRS to target Tea Party volunteers for harassment and intimidation in advance of the 2012 presidential election. In the 2016 presidential election, the FBI, the DOJ, and our intelligence agencies used their power to legitimize the lie that had been concocted by the Hillary Clinton campaign that Trump was colluding with the Russians. Despite knowing this was a lie, these agencies used their powers to legitimize it, to authorize spying on the Trump campaign, and to terrorize its supporters. And when this failed, they continued to pursue it, to undermine the Trump administration, question the legitimacy of the election, and shook this country apart for more than 2 years before the lie was finally fully exposed to the public thanks to the Inspector General's reports. Then we have the 2020 presidential election. Hunter Biden's laptop contained emails that clearly documented long-standing influence peddling scheme involving the Biden family, in which millions of dollars were paid. Yet 52 high-ranking intelligence agency officials signed a letter circulated by the Biden campaign calling it Russian disinformation. And although the DOJ had that computer in its possession and knew it was authentic, they suggested otherwise and then used their power to pressure social media companies to censor and suppress that story. Pollsters have reported that action alone could have decisively influenced the 2020 election. And now we have this. And I'm sorry to inform the ranking member, but Jack Smith was one of the principal figures in the IRS scandal. He had a history of prosecutorial misconduct, culminating with unanimous reversal by the U.S. Supreme Court. Yet he was the one appointed by the Biden administration to try to put their chief political opponent in jail. Biden's Attorney General personally approved a raid on a former president's home despite strenuous opposition by career DOJ officials and by the local field office that would normally have had jurisdiction. Alvin Bragg, who campaigned by boasting he'd prosecute Donald Trump, was joined by the number 3 official in the Biden Justice Department. Nathan Wade, named prosecutor by his paramour, Atlanta DA, spent 8 hours consulting with the White House counsel at the White House before filing these felony charges, not to mention the multiple failed attempts by Democrats to throw Trump off the ballot. This administration, its Confederates, have broken every political norm, every civil tradition, every due process protection that shielded Americans from the convulsions suffered by banana republics. And we can now clearly see the full power of leftist lawfare. We always thought this couldn't happen here, but it has. And my question is what can be done by Congress, first of all, to close this Pandora's box and assure that it is never opened again? Mr. Bailey?
I think this body has a duty to erect a wall of separation between tech and state to prevent government censorship of conservative voices on big tech social media platforms. As you pointed out, the deep state has actively suppressed information that interfered with the 2020 election. I think that will continue to happen as we move into 2024, and I think the distinguished member is absolutely right that we've got to stop looking at lawfare in terms of trees and start seeing the forest for what it is. It's censorship, it's civil suits, it's President Trump being unconstitutionally stricken from the ballot in states, it's now criminal charges.
It's the turning of the most terrifying powers that government possesses against its own citizens to influence elections, and this has been going on now through several cycles, and now it's getting to a whole new level. Mr. Traynor?
Thank you for the question. I think it really comes down to the fact that we have to get away from allowing government to be the weapon to interfere in political participation.
How do we do that?
I had the opportunity last year to testify before the House Administration Committee on this very issue of how complaints are filed with the Federal Election Commission and used to do nothing but go investigate political opponents under the guise of the federal government conducting a legitimate investigation, and they ultimately turn out to be nothing at all. In fact, the most infamous one that I talked about was a gentleman who spent $348 on a Facebook page. The allegation against him was that he had spent $23,000 on a Facebook page, and he spent 3.5 years being investigated.
Right, and word gets out to anybody else, don't even go near the political process because you will expose yourself to this kind of liability. I know Tea Party volunteers who today won't go near politics for fear of invoking the harassment of the IRS. What really frightens me is what happens to our country when Trump, if Trump narrowly loses the election and the case is then overturned and repudiated and exposed by the higher courts. That could tear our country apart. Ms. Foley, final word?
Well, I mean, I think there are a few things that at a minimum should be done. One is to defund the district attorneys and actors who engage in these nefarious acts. Two, I think the Congress needs to use its oversight authority. It has clear oversight authority under the Civil Rights Act to make sure that law is not weaponized to prevent people from exercising their First Amendment freedoms and other constitutional rights. And I think that's really a pattern that's going on today. I think there's mass intimidation through lawfare and other means to intimidate, especially those on the right, from speaking their mind, from gathering, from assembling, from protesting. I think also we're, to a certain extent, we're late to the game as conservatives and Republicans, but we have to start engaging in lawfare of our own. I think there's various ways, for example, that Mr. Trump, if he wants to.
Well, my time is up, but I hope we don't do that. We must never allow the left to become our teachers.
Well, but there's good lawfare and there's bad lawfare.
The time of the gentleman has expired. The gentlelady from California is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to start off by recognizing that the felony convictions of a former president represent a first for our country, and that is solemn. I don't celebrate these convictions. It's disappointing when crimes are committed, but it may be even more disappointing when our country's justice system gets criticized for political ends. I, for one, don't always agree with the outcome of cases, but I do respect the process and especially the public servants who do their jobs. Now, some of my colleagues on the other side of the aisle claim the verdict against the ex-president is, and these are all quotes, a travesty, rigged, a sham, that the jury of peers who assembled to do their civic duty delivered a, quote, rigged verdict, that a defendant afforded due process was part of a, quote, witch hunt, that the DA is, quote, corrupt, the judge is corrupt. Corrupt seems to be a big catch-all. I saw a judge that made rulings in favor of both the defense and the prosecution, and who provided clear, lawful instructions to the jury. Now, some of my colleagues say the Department of Justice, a federal agency that is part of the Biden administration, somehow directed the Manhattan District Attorney to indict Mr. Trump in a New York state case. Ambassador Eisen, can you please help correct that specific fallacy? What jurisdiction was involved with this hush money and election interference case? The state of New York or the federal government?
This was a case that was brought by the Manhattan District Attorney under New York state law. The federal government had no role in that. Is a fundamental misunderstanding, Ms. Lofgren, of our federalism to confuse the role. It's a conspiracy theory, and the Department of Justice just this week debunked that conspiracy theory with the AG issuing a letter saying there's no evidence.
So it's fair to say that the Biden administration was not involved in this case?
Not whatsoever.
Okay, and just to make things clear, it's fair to say that President Biden himself was not involved in this case?
Not involved in this case, and indeed has given extraordinary latitude even on the federal side to his own Department of Justice, including to prosecute his own son.
In addition to muddying the waters about the current administration's involvement, the loud criticism, ironically from some who say they back the blue, can really erode Americans' faith in the justice system. Now, that is a problem for basic law and order in our country, and I think it also puts lives at risk. The number of threats targeting federal judges has more than doubled over the last 3 years. And at the local level, threats and harassment against local public officials rose last year too. Now, Ambassador Eisen, can you please talk about these increased threats to public officials as well as distrust in the system? How harmful both of those could be to our country's independent judiciary and really our democracy?
They're devastating, Ms. Lofgren, and one of the worst outcomes of the former president's incessant flow of disinformation, the attacks that you describe on the judge, the jury, the prosecutor, the system, is to incite those threats. We know that his incitement led to the tragedy of January 6th. We saw that in this body. But the constant flow, when I read the well-founded factual predicate for the gag order in this case, the sheer number and explosion of threats against the DA, they documented hundreds of these threats that were received. It's chilling. That is a tragic consequence of Donald Trump's irresponsibility.
Can democracy survive if the rule of law is eroded?
One of the privileges of my life was to sit on the dais in the first impeachment of the former president between the ranking member and Ms. Lofgren. That process demonstrated to me that a vibrant rule of law is the foundation of a strong democracy. I believe our democracy will survive, but we have not seen such a profound internal threat as this promise of day one dictatorship since, in my view, the end of Jim Crow or the beginning of the Civil War.
Thank you. Mr. Chairman, my time has expired. I yield back.
Gentlelady yields back. Commissioner Traynor, I want to read from your testimony. They have sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had taken jurisdiction and couldn't prosecute. I want you to unpack that sentence for us again real quick.
Thank you, Mr. Chairman, for the question. The Department of Justice, all of these claims with regard to the $130,000 from Ms. Daniels stem from a complaint that was filed at the Federal Election Commission following the 2016 election.
But you guys were investigating.
We were in the process of investigating that.
And the DOJ came to you and said, stand down, we're taking over, and give us your information.
They asked us to abate that and several other
DOJ
matters.
meeting the Southern District of New York.
That's correct.
They took your information, and you voted to stand down and give it to the federal authority, right?
That's correct, Mr. Chairman.
And they determined that there was nothing there to prosecute other than Michael Cohen.
That's correct. Now, they took a very long time in doing it, and when they sent it back to us, we had no more authority to investigate because they sent it back to us, and we were barred by the statute of limitations from even investigating the normal civil things that we would look at with regard to those type of expenditures.
But your point here is they've sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had intervened, to use the word, and taken jurisdiction from you and concluded there was nothing there regarding a federal statute, right?
That is
a, quote, federal crime that they come up with somewhere.
That is correct, Mr. Chairman, and I don't know what role Mr. Coangelo played in that investigation that took place when they took it away from the Federal Election Commission, did that investigation, and then he later left the office to go prosecute this at the state level.
Well, we're going to find that out on July 12th when Mr. Colangelo will be sitting in your seat, Mr. Bragg will be sitting in Ms. Foley's seat, and we'll get a chance to ask him. Mrs. Foley, excuse me, the Democrats talk about, jury of his peers. Okay, fine, that's how our system works. But if President Trump didn't learn what the unspecified crime was until the jury got the instructions from the judge, that sort of changes the dynamic a little bit, doesn't it?
Yeah, it's not blaming the jury. I mean,
of course.
The jury, has to operate according to the instructions provided by the judge. The poison here, the poison pill, are the jury instructions themselves, which provided the notice, but it came too late for purposes of due process. So yeah, I mean, you can't correct that through a bad set of jury instructions. If there's a due process defect because he learned too late, you have to redo the trial. You have to reverse the conviction, and then the prosecutor has to decide if they want to. Yeah.
I was an economics major. I majored focused on wrestling, but you had to get a degree. I got one in economics, and they talk about this opportunity cost. If you don't know what the issue is, you miss the opportunity to maybe focus in on the issue as the defense counsel, right?
Yeah.
That's kind of important, particularly when you're talking about what kind of sentence they may try to impose on the president on July 11th. That's kind of important, right?
It's kind of important, and I would suggest that any member of this committee who faced similarly amorphous charges or a loved one would be absolutely incensed by facing these kinds of charges, where it was a moving target.
You're not the only constitutional scholar who's raised this concern, this, I think, huge concern. Mr. Dershowitz, Mr. Turley, I mean, other esteemed constitutional scholars have said the same thing.
I'm in good company. I think there's a general consensus that there are some due process problems here.
You sure are. Mr. Attorney General, July 15, 2021, Alvin Bragg. I'm the candidate in the race who has the experience with Donald Trump, and I think it'd be hard to argue with the fact that that'd be the most important, most high-profile case, and I've seen him up front and seen the lawlessness that he could do. That's what he said as a candidate. Does that fit with kind of the ethics of someone who's a member of the bar and running for a district attorney's position? Is that how you're supposed to conduct yourself in a campaign?
Absolutely not. That abhorrent statement is an incurable impropriety that should have disqualified Alvin Bragg from prosecuting that case.
Yeah. Not to mention, then when he gets the job, he looks at the facts, looks at all the evidence, and he concludes, like, this case, I shouldn't prosecute it. I should do what the Federal Elections Commission did, not prosecute. What the Southern District of New York did, not prosecute. What my predecessor, Cy Vance, did, not prosecute. That's what he wanted to do until the political pressure came. They talk about us all the time, pressure. Came from the left. Mark Pomerantz left his job, volunteered, goes and becomes an assistant district attorney to go after President Trump. And then when Alvin Bragg gets there and looks at how crazy the case is, and Michael Cohen's going to be their star witness, he goes, this is crazy. I'm not doing it. I'm not that crazy. But then they leak, Pomerantz resigns, leaks the letter, and all the left goes crazy. And Alvin Bragg says, now I'm going to do what I said during the campaign, even though I know it's wrong. And that's what happened. And then they got a judge who went along with all the crazy things Ms. Foley's pointed out. That's the story, and that story is consistent with the facts. That's why we're here today, and that's why we look forward to Mr. Bragg and Mr. Colangelo sitting right where you're at so they can answer our questions.
Mr. Chairman, I have a UC request.
Gentleman state his request.
Mr. Chairman, I ask your unanimous consent to enter into the record a letter from the Department of Justice confirming that it had no role in the Manhattan trial.
Without objection. Chair now recognizes the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman. MAGA Republicans are trying to make the American people believe a false narrative, that being that Alvin Bragg, a state prosecutor, was somehow manipulated by federal officials, Biden officials, Justice Department, to prosecute and persecute Donald Trump. And the fact that this committee, the Judiciary Committee, is trying to get Americans to buy into this false narrative is concerning. Wouldn't you say so, Mr. Eisen?
It's deeply concerning. It undermines Americans' faith in the rule of law, in the Department of Justice, which has been quite independent from President Biden, and it's baseless. There's no evidence for it. It's debunked. It's a conspiracy theory. The ranking member just entered the proof into the record submitted by the Department of Justice. More proof. It's wrong.
So how does this kind of federal placing of the thumb on a state institution, the judiciary, the rule of law, the prosecution, the justice system of a state, how does it come across to state and local officials when the federal Congress, when the Judiciary Committee of the United States Congress, the House of Representatives, is trying to bully them? What impact does that have?
It doesn't come across well. Fortunately, DA Bragg, as he said he would during his campaign, he stated that he had, I don't know where this investigation will go. I don't want to prejudge it. He maintained independence. I was there in court every day. There were no federal prosecutors there calling the shots. They were strictly independent. But it requires that courage and integrity. The pressure is felt on the part of state and local actors. Not all of them may show that same independence, and they may knuckle under and not investigate. And with Donald Trump promising to be a dictator starting on day one, that means to attack the rule of law. We need our state institutions to be stronger. That's the American idea of federalism, not to intimidate, threaten, or put the thumb on their scales.
And so when you talk about intimidating and threatening behavior by bullies, how does this translate into physical threats or the possibility thereof?
Just look at the submissions that the DA made or other prosecutors have made in response to this disinformation campaign, these attacks led by the former president. It opens the floodgates. Mr. Johnson, I don't need to tell you, like the "will be wild" tweet opened the floodgates of January 6th. It is a clear and present danger to American democracy.
When it comes to state prosecutions which depend on jurors, like the 12 brave jurors in the case in New York, how do efforts like these that we're going through today affect states' abilities to procure juries and jurors to handle or to serve on cases in those jurisdictions?
It creates a challenge. I was there also for the voir dire, the jury selection in the Manhattan election interference and cover-up trial, and you had to get hundreds and hundreds of jurors. Half of them chose not to serve, in part because, right from the get-go, in part because of this climate of intimidation. Several who were selected felt they couldn't do it. I do salute the jury, though, and the judge, and I will say the lawyers on both sides, because they ran a courtroom together where those 12 jurors were able freely and fairly to weigh the evidence, apply the law to the facts, and find Donald Trump guilty without fear or favor.
And not one of those jurors has chosen to speak out, whereas you've had jurors in the Hunter Biden case who decided that case speak out. Why is that?
They're very smart. It was one of the, I do juries for a living, and it was one of the most attentive, smartest, engaged, plugged-in juries, and I think it's smart that they're not stepping forward because of this climate of threats and harassment. Imagine if the former president were to recover the powers of the Oval Office and the federal government, or if he could subvert his DOJ as he sought to do, turning them on the legitimate election results of 2020, the level of intimidation that our state and local prosecutors and our jurors, everybody involved in the justice
the gentleman has expired. The gentleman
would
yields
feel.
back.
My
Gentleman from
apologies.
Wisconsin is recognized.
Thank you, Mr. Chairman. Mr. Eisen, I just want to make sure you answered the ranking member, I think, and I want to make sure I heard it correctly, that you said President Trump's interference in the 2016 election.
Correct.
Is that correct?
That's correct.
That he interfered in the 2016 election?
Yes, sir.
And real quickly, how so?
The jury unanimously found in the Manhattan case that former President Trump had committed 34 felony violations of document falsification.
You weren't referring to anything else?
No, that's not true. That's disinformation, sir.
Yeah, okay.
In order to find that, they were charged with election interference. The underlying crime that made that a felony, not a misdemeanor, was election interference. Same pattern as 2020.
So it's all about election interference in 2016 also. Ms. Foley, so we heard from the gentleman that's to your right that he said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting a sweetheart deal? Do you recall the details of that?
Yeah, I mean, they were basically just going to let him walk for all of them. They already allowed statutes of limitations to expire on multiple of the more serious felony.
So how did that happen that we actually may get justice in that case?
Well, I mean, look.
Wasn't it the judge that
you know,
threw out the sweetheart deal?
Yeah, I mean, you had a judge in Delaware that threw out the sweetheart deal, yeah. And then, you know, I guess there was egg on the Biden administration's face, so they felt like they had to do something, so they pursued these current charges, the gun charges and the tax charges. But, you know, I mean, did they reach the right result? I assume so. I didn't follow that trial very much. I think there'll be an interesting question as to whether the president commutes his son's sentence, so we'll see.
Which is, yeah. So, also the gentleman next to you referred to under questioning, he said this trial and jury was scrupulously fair. It was outstanding. There was nothing unusual. Care to comment on that?
Well, again, I mean,
you could start with nothing
I'm not
unusual.
blaming the jury here. I think the poison came from the behavior of the prosecutors hiding the ball, and then Judge Merchan giving sort of a cafeteria-style approach where non-unanimity was allowed on the underlying means by which the New York election law was violated. I think those are clear due process violations. So it's not the jury's fault. They just had, you know, junk to work with, so to speak. I was going to use another word, but I probably shouldn't.
It's almost enough to shock the conscience, huh?
It's almost enough. Yeah, it shocks mine. I don't know about yours, but.
I believe it's correct, and I can be corrected on this if I'm wrong, but I believe the judge contributed to President Biden, the judge in this case. Is that common for a case that has a real nexus that the judge would contribute and then not recuse?
I've never seen a case like that. I mean, usually a lawyer feels pretty confident if he finds out that the judge has overtly, you know, expressed preference for one party or another, and political contributions to the Biden administration would seem to fit that bill, given the political overtones of this case, right? This was not an ordinary state prosecution. This was a state prosecution that, if successful, even though it had been turned down at every other level to even proceed as a prosecution, if it proved successful, it would basically interfere with the 2024 presidential election. And possibly that interference could not be remedied, could not be rectified until after the election. So it's slam dunk 2024 election interference.
It's almost reminiscent of Jack Smith and Governor McDonnell in Virginia, isn't it?
Right, and he got his you-know-what handed to him by the Supreme Court on that one.
I want to get a question into Attorney General Bailey here. Talk about the overall chilling effect in regards to this. In fact, I believe it was Governor Hochul, after this charge happened, went on media in New York and said, hey, don't worry, this isn't going, we're not coming after the rest of you business people. This is just Donald Trump. Talk about the impact of something like this for the long run in the rule of law.
The Constitution is our national identity. Those rights codified therein come from God, not man, and the document is intended to protect us from the government. And yet what we see time and time again is the government being weaponized against individuals. It's President Trump today. Who will it be tomorrow? And that's the problem. I think that when you look at the due process issues contained in the charging document, ultimately in the jury instructions, and you look at the inchoate nature of the offenses with these ill-defined levels of attenuation, it's as if invisible links of chain are necessary to connect the facts to criminal liability. And it causes the jury to turn into a roving commission, free to pursue whatever facts they want to attach liability as they please. And the issue there is it undermines the rule of law for the rest of us. Who can have confidence that we know what is and isn't illegal behavior when the court and the prosecutor impanel a roving commission to attack a political opponent?
I yield back, Mr. Chairman.
Gentleman yields back. The gentleman from California is recognized.
I want to begin by quoting the jury in the Manhattan hush money payment trial. Guilty. Guilty, 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 guilty. This was what the jury pronounced unanimously on every count. My Republican colleagues don't really contest Donald Trump's guilt. This is the fascinating thing. Their argument is essentially he should never have been prosecuted, or they falsely claim it was a political prosecution, or they falsely claim it should have been a misdemeanor, not a felony. But they don't contest, not really, that Donald Trump was making hush money payments to a porn star to hide their affair from voters. What they're really saying is they're more than comfortable nominating and electing as the President of the United States someone making hush money payments to a porn star. The party formerly of the moral majority is now, I suppose, hoping to fashion some kind of immoral majority to reinstate Donald Trump as president. The presidency, the most powerful office in the world, and not the most powerful because of the size of our military, but because of the power of our ideas. And what is the animating idea of a Trump presidency? It is dictatorship. It is power at all costs. And this is also tragically the animating idea of the Republicans on this committee. Power at all costs. What else can explain what it would profit them to give up their political soul but a world of power? Ambassador Eisen, I want to ask historian Eisen a question. Is there any period of our history that sheds light on what we're going through today? Have we ever seen one party or the other so completely abandon oath to Constitution, commitment to truth, commitment to decency, so willing to tear down the rule of law, our institutions, our justice system, anything that gets in the way of power? Have we ever seen anything like this?
Three periods come to mind, Mr. Schiff. The first is the founding period, and in particular, the ferment between the Articles of Confederation and the Constitution, when the founders and the framers, famously the Federalist Papers, a passage you know well, worried about that in that period of instability, a tyrant would arise. That was resolved by one of the fortunate accidents, not just in American history, but I dare say in the history of the world, George Washington's establishing the tradition of peaceful transition that Donald Trump ultimately broke for the first time in our history. Number two, the Civil War period, when we had those within who also proclaimed that they would not accept American rule of law. And that period of divisiveness is also found in the post-Civil War era, the decline of Reconstruction, that assault on our constitutional system that became the Jim Crow era. Those are three precedents. We see other dangers, including here in Congress, the period of McCarthyism. Donald Trump represents the most grave danger to this country, at least since the end of Jim Crow, very likely since the commencement of the Civil War, and perhaps since the founding of our nation from within.
Thank you, Ambassador. Mr. Chairman, I'll yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
Thank you, Chairman Jordan. This is amazing construction of some kind of crime here, but when we dig down to the bottom of it and try to find out what the underlying crime is, I don't think that's been discussed enough, or what the supposed underlying crime is. One of the propositions was that hush money should be reported as a campaign finance expense. Okay, if somebody pays their attorney to seal divorce records because they may be going to run for office, or they are running for office, Mr. Traynor, is that a campaign finance expense? Is that something you see on campaign finance reports?
That is not. It is something that you would see. Legal fees are often reported, and it has been the tradition at the commission in looking at those legal fees that we don't question what the attorney-client privilege between the candidates and the lawyer are